and we're really excited that we now have the chance this morning to sit down with you to talk about how you can craft an effective estate plan without starring in Family Feud. Now, I know we all love to watch Family Feud once in a while, but none of us ever want to find ourselves in the middle of a Family Feud, for sure. And we also want to make sure that our kids don't break out in their own feud after we pass away. So to help you figure out how you can try to prevent that conflict from breaking out in your own family, in the next 45 minutes, you're going to discover different types of long-term care options and how to pay for long-term care, the absolutely critical legal documents that you have to have ready, different asset protection strategies, and why a trust might make sense for your family. And we're going to go over all of this today so you know exactly what you need to do next in order to prepare yourself and your family for your long-term care in the second half of your life. So this seminar today is for you if you're unsure of how or where you might be receiving care in the future, if you have any fears or if you're scared about not being able to make your own decisions someday, if you feel any anxiety about who you should designate as your decision maker in your powers of attorney or in your other documents, or if you're worried about what's going to happen to your children after you've passed away. And if this sounds like you, let me tell you, you are not alone at all. We help clients all day, every day who have these exact same fears and worries and anxieties. And our goal is to try to help you have a plan in place for yourself and for your family to help for your long-term care and to protect your assets from your long-term care costs so that you don't put a burden on your family. We also want to make sure that your spouse and your beneficiaries are protected from any costs of long-term care you might incur in the future. We also want to help you prevent a conflict from breaking out within your family. And we ultimately want to give you the peace of mind to know that you have done everything you can to prepare yourself and your family from what might happen in the second half of your life. We were actually able to do this exact thing for one of our clients, Patricia Fry and her husband. And after we were able to help walk them through the asset protection strategy and help them through all of these same fears and worries that you might be facing today, this is what Patricia had to say. I'm sure glad I made the call. My husband had experienced some health challenges, so we knew it was the right time to put things in order financially to be properly prepared for the future. The thing I most appreciated was that they listened to what we needed and then provided outstanding guidance throughout the entire process. It was as if they developed a roadmap that we can now follow. They made things so easy, and there's no one I would want to take care of us more than these people. So we're so hopeful that we are going to be able to help you and prepare you in just the same way that we were able to help Patricia Fry and her husband. But before Kristin and I dig in today into what exactly you need to be thinking about for how you can get yourself and your family in that same position, I'm going to take a step back and tell you a little bit more about myself and my background. So as Haley said when we started off, I'm Megan Ingram-French, and you can see here pictured with me is my husband, Brian, and this is our golden doodle named Poppy. Poppy has grown quite a bit since this picture was taken. She's no longer this little fluffy fur ball that you see in the picture. But actually, she isn't the only thing that has been growing recently. My husband and I are expecting our first child in about a month from now. And I am just so excited to welcome my son in very, very soon. So if any of you hop onto another seminar with me in the future, you'll probably see a picture that looks a lot like this and resembles this. But most certainly my dog is going to be replaced and I will be holding my son instead. Poppy's about to take a back seat real fast in our family. But I am one of the new attorneys here at Steinbacher, Goodall, and Yurchak. I actually just graduated from Penn State Law in 2020 in the midst of the COVID-19 pandemic. And while I was at Penn State Law, I focused my studies on taxation and different tax issues. And I also had the opportunity to work here at Steinbacher, Goodall, and Yurchak as a legal assistant for a couple years before I was able to move into this position. So I was really thankful to have a couple years working for attorney Jenna Franks and attorney Amos Goodall, trying to soak up every little ounce of knowledge that I could before I stepped into this role as an attorney. And before I went to law school, I graduated from the Smeal College of Business at Penn State, and I have a degree in finance with a minor in business law. But those, the business studies that I did was sort of just like a pit stop along my journey, because I've actually known since I was 14 years old that I wanted to be an elder law attorney. And whenever I tell people that, the follow-up question I get immediately is, how did you ever decide that whenever you were 14 years old? Well, the reason I decided to come into this field is because of my path. And you can see him here. We were incredibly close. He passed away about 11 years ago now. And towards the end of his life, he developed dementia. And very sadly, one of our family members took advantage of him because of his weakened mental state. And so while we were going through that time, my family actually had to hire one of the attorneys here at Steinbacher, Goodall, and Yurchak to help us through that and to help us try to resolve that conflict that broke out in our family. And so as difficult as it was for us to go through that time, and as heartbreaking as it is to look back at everything that we went through with that time, it is really interesting for myself and for my family to look back and sort of see the silver lining to all of that, that now because we went through that, now I'm here working for the exact same firm that we turned to for help. And now I'm just so thankful for the opportunity to get to help other families through very similar situations that I went through. But at this time, I'm going to turn it over to my co-presenter, Kristin, to introduce herself to all of you today.
Thanks, Megan. I'm really excited today. This is Megan and I's first presentation together. So if you have listened to any of our other seminars, generally Jenna and I present together. So this is exciting, something a little bit new and different. Now, I also want to apologize. I have a little allergy or sinus thing going on, so my voice isn't as delightful to listen to as it normally is. So I apologize in advance, but my name's Kristin Daugherty. I am a long-term care planner and a certified Medicaid planner with Steinbacher, Goodall, and Yurchak. I am also a certified dementia practitioner and also an Alzheimer's disease and dementia care trainer, which allows me to train other professionals to become certified dementia practitioners. Now, I've been with Steinbacher, Goodall, and Yurchak for 10 years, and prior to joining the firm, I worked for the Area Agency on Aging for 5 years. Now, this is my family. So my husband, Kyle, my 11-year-old daughter, Kendall, and my 6-year-old son, Kyler. And we also have a variety of pets. Somehow everybody, including my children, have red hair, chestnut colored. We have our dog, Chestnut, our cat, Sprinkles. They really just like each other. So thankfully, my dog's not here right now to chase the cat around. We did have a fish also, but my husband and I took a trip last month, and my cat decided to get in the fishbowl and have himself a little snack. So we also have some horses, which is really my daughter's passion, is riding, and her first 4-H show is coming up here in just a few short weeks. But how did I get here? Well, I like to compare it to Alice in Wonderland because I kind of fell into it. I always knew that I wanted to help families. And when I went to college, went for sociology and psychology, started off with an internship at a drug and alcohol facility, but I knew right away that was not for me. And luckily I landed into a position with the Area Agency on Aging. And I'm so glad that it worked out that way. I absolutely loved working at the Area Agency on Aging, helping families every single day. But like many social service agencies, resources, funding, and manpower is really limited. So that's how and why I ended up transitioning to Steinbacher, Goodall, and Yurchak, where we have additional resources, and I am able to go above and beyond every single day, doing what I really love to do, helping families, protecting spouses, and giving really good advice. So I work alongside the attorneys here at the firm, exploring options for care, applying for benefits, connecting seniors with resources, and most importantly, advocating for those in need. But really, one of the main reasons I'm so passionate about what I do is because I get to help people like Nancy. So I would love to tell you Nancy's story, but I think her testimonial is so wonderful and says it all. After my husband went into the nursing home, I went to another law firm in the area to see what could be done about paying for his care. They said there was nothing they could do for me and that I'd have to spend down my money for him to then be eligible to receive Medicaid. I was very concerned and felt they just left me on my own. I was later told to call this firm. I figured why not, because at this point I had nothing to lose. After explaining my situation, I was told to come in right away because I required immediate attention. What they did for me was unreal, especially after being told I was in a hopeless situation by that other firm. They took action to protect our assets and get my husband's nursing home bills taken care of into the future. Everyone was so wonderful. I'd taken my daughter with me, and when we were told the bills were going to be paid, she cried because she knew what the other lawyer had previously said. I can't say enough about this kind of attention to detail. But today isn't about Nancy. It isn't about us. Today is about you. Our goal for you today is to give you the tools so you know what you can do to avoid a family feud and make sure that you and your loved ones are taken care of during your second half of life. We're going to discover the top 3 answers on that family feud board: types and cost of long-term care, essential estate planning documents, asset protection strategies. We're going to take you from where you are right now to where you want to be. Let's get started by diving into the family feud poll question number 1. What care options are available and how do you pay for care? So let's start about what type of care is available. In order to put a plan in place, it's really important to know what options there actually are. It's always surprising how little we actually talk about this throughout our community. So I think it's really a good conversation and one of the first conversations we always have with our clients when they walk in our door. Now, in our areas, we're very lucky to have a variety of ways to receive care. Care choices range from in-home care to facility care, with many options in between. Most of us want to stay home no matter what, which is great as long as it's practical and safe. There are agencies that provide in-home care services, or you can also hire individuals to provide care in your home on your own. If you need some socialization or your caregivers need some respite, there are adult day centers that are available to help provide a little additional help so you can stay home. However, at times, in-home care is not enough and facility placement is necessary. Placement options can range from independent living to personal care homes, otherwise known as senior living communities, to memory care communities, to skilled nursing homes, or even continuing care retirement communities. Let me share a little bit of information about each of these facilities and what they offer. First, personal care or senior living communities are a great option for someone who needs some supports outside of their home. These facilities provide meals, medications, some supervision, activities, and some assistance with medical needs, personal care needs, and memory support. Now, these communities can range in anywhere from maybe $3,000 a month to $8,000 a month, really depending on the community itself and what your needs are. Now, memory care facilities are a great option for those who have memory impairments but otherwise are healthy. These facilities focus on memory enhancing activities and therapies while meeting all of their residents' needs and providing a safe and secure environment. Skilled nursing facilities are the highest level of care and often have the most medically or cognitively impaired individuals living there. Now, skilled nursing homes in Pennsylvania cost on average over $11,000 a month. That's well over $132,000 per year. That is a lot of money. Now, continuing care retirement communities typically encompass all of the above, starting at independent living through personal care, all the way through skilled. This is a great option for anyone who wants to age in place. Now, continuing care retirement communities generally only accept private pay, and the cost can range based on the community you're residing in and the level of care. Many continuing care retirement communities also have a large buy-in. All of them really work a lot different. So if you think a CCRC, a continuing care retirement community, is a good option for you, it's really important to explore and tour and ask lots of questions to make sure it's a good fit. Now you might be wondering though, so we're talking about these levels of care. You've thrown out some ideas for how much they might cost, but how do you pay for it? What are our options? So of course, any place you reside, you can privately pay for your care. But at over $11,000 a month for skilled nursing home care, you could quickly become impoverished paying for this care out of your pocket. Now, if you are a veteran, a spouse, or a widow of a veteran, you may be eligible for the aid and attendance pension benefit through the Veterans Administration. This can be a benefit of up to around $2,000 a month if you meet the medical and financial criteria for the program. There's long-term care insurance, which is a great option. Every long-term care insurance policy works a little different, so you need to make sure you know what it covers if you need care. For instance, what type of care does it cover? Does it cover in-home care? How much is the daily benefit? With the average daily cost over $350 a day for nursing home care, a policy that only pays $100 a day isn't going to be good enough. Let's talk about Medicare. Most Medicare recipients think that they will receive 100 days of Medicare coverage annually if they go into a nursing home. Sadly, this really isn't true. Medicare was designed as a short-term solution to long-term care. It covers up to 100 days annually. Most individuals only receive around 20 days of coverage, so you can see why it's really important to have other options in place to help pay for your care. Lastly, let's talk about Medicaid. Now, as one of the few certified Medicaid planners in Pennsylvania, I could talk to you about Medicaid all day long, but I will certainly bore you and you will fall asleep. But did you know that most residents in nursing homes are actually covered under Medicaid? You might be thinking, but wait, isn't Medicaid an impoverishment program? And yeah, it is. But there are strategies that we can implement to get you qualified for Medicaid and protect assets from nursing home costs. There's even a Medicaid program that pays for in-home care. Now, Medicaid planning is very complicated and strategic, even for a situation that may appear to be simple. In a little bit, we're going to dive into assets and Medicaid qualifications to give you a little bit more of an understanding about how that might work for you. But first, I think we should switch gears. I'm going to have Megan jump back on here, and she's going to talk about the Family Feud poll answer number 2, essential estate planning documents that everyone must have.
Thanks, Kristin. So yeah, I'm going to get us started on our second poll answer. And so what are the essential estate planning documents you have to have in your second half of life? And the most essential estate planning documents you have to have ready are your powers of attorney, your last will and testament, and maybe a trust. So Kristin, would you please go ahead and move the slide? Thank you. So I know some of you might be sitting at home today thinking, oh, well, I have a power of attorney in place. I have a last will and testament, so I'm good. I have those documents. However, the thing that we really want to stress to you today is that not all estate planning documents are created equally. It might not be enough just to have just any power of attorney or any last will and testament, but we want to make sure you have a good power of attorney or a good last will and testament or a good trust. Because the problem is, if you have maybe a not so good document in place, then you run the risk of possibly not allowing your spouse, your kids, or any other decision maker you appoint having the power that they need to actually do everything that they need to do to help you. If you don't have a good estate planning document in place, then your family might have to pursue a legal guardianship over you instead. And if you have to go through a guardianship, you could risk losing a lot of control over your assets and your own decision making. Not having good estate planning documents also puts you in the risk of impoverishing your spouse, because you just might lose everything you have or almost everything you have to a nursing home or to your other long-term care costs. And also, of course, if you don't have good estate planning documents in place, you also really heighten your risk of having a conflict break out among your family members, because it isn't clear what they should be doing to help you through this time. So now you might be wondering, okay, well, of the essential estate planning documents, what is the most essential of the essential estate planning documents. And without a doubt, that is the power of attorney. You absolutely need to have a power of attorney. This is the document that allows a decision maker or your agent have the authority to make decisions and act on your behalf. And here at Steinbacher, Goodall, and Yurchak, we actually break out the power of attorney into 4 different documents. We do a financial power of attorney, a healthcare power of attorney, a living will, and a mental health power of attorney. So to get started with your financial power of attorney, I think this is the document where it is the most crucial. Kristin, would you mind please going back to the previous slide? Thanks. So with your financial power of attorney, that is where the difference between a good financial power of attorney is huge, between a good financial power of attorney and a not so good financial power of attorney. This is the document that gives your agent the power to control your assets and your finances and to take care of those things for you. And whenever we're looking at a financial power of attorney that someone brings in to determine if it's a good power of attorney, there's a lot of things that we look for, specifically because in Pennsylvania, your agent is actually not allowed to do something for you unless you specifically say in the document that they're allowed to do that thing for you. So if you want your agent to be able to do X, then your financial power of attorney needs to say, my agent is allowed to do X. And 2 of the powers that we really, really look for in a financial power of attorney is the power of your agent to create, amend, and revoke revocable and irrevocable trusts, and the power to do unlimited gifting of your assets. And the reason why those are so crucial to include in this document is it gives your agent the power to do asset protection for you. So maybe you end up in a nursing home or you need some other kind of long-term care and you haven't already done asset protection planning or you haven't fully done asset protection planning. And having these powers in your financial power of attorney lets your agent set up a trust for you and help to protect some of your assets, which Kristin is going to talk to us more in a little bit. So we could probably do a whole seminar just on financial powers of attorney and what all you need to have in them and how important they are. But for the sake of time, I'll move ahead to the healthcare power of attorney. This is the document that allows your agent to make decisions for you for your medical care if you're not able to communicate your own decisions on your behalf. This includes things like consenting to surgeries, authorizing, withholding, or withdrawing medical treatment, and admitting you into or discharging you from a hospital, a nursing home, or some other kind of healthcare facility. We also have you do a living will. And at first glance, it might seem like the healthcare power of attorney and the living will kind of do the same thing, but we're really going to pull out these 2 documents in 2 very different situations. Your healthcare power of attorney is a document that comes in whenever you're unconscious, you're not able to communicate your own decisions, but the doctors are expecting you to be able to recover or your condition to improve if you receive treatment. On the other hand, the living will is the document that we're going to look at if the doctors are saying that unfortunately they have done everything that they can and there's nothing else that they can do at this time to give you a realistic hope of a significant recovery. This is the end of life document. And the living will is the document that lays out your preferences regarding life support. And in Pennsylvania, it is so crucial that you have a living will in place, listing your wishes and your preferences on this type of care. Because in Pennsylvania, if you don't have a living will in place, your family is going to have to prove with clear and convincing evidence that you wouldn't want life support measures in this situation. And clear and convincing evidence is the highest burden of proof that you can have in Pennsylvania, and it can be really difficult to prove. But if you take the time to have a living will in place beforehand, clearly listing what kind of care you want if you're in that situation, it makes that process so much easier and so much less burdensome on your family. And the last power of attorney that we do here is the mental health power of attorney. This is a newer document in Pennsylvania, and it's specifically targeted to any mental health treatment that you might need. And it gives your agent the power to consent to different medical studies or drug trials. It also covers such things as electroconvulsive therapy, anything specifically targeted to mental health powers of attorney. So that is an incredibly brief run through of all of the different powers of attorney, the most essential of the essential estate planning documents. But you might be wondering, why is this document the most important one I have to have? Well, the reason why you absolutely need powers of attorney is because if you want your spouse to be able to act for you, and if you don't already have a power of attorney in place, your spouse might not automatically be able to act for you on your behalf. Now, there are some areas in Pennsylvania law where the law sets out very limited scenarios where it makes some assumptions of who you might want to act for you if you're in certain situations. But like I said, those default rules that the law has only applies in very limited situations. And the law is making assumptions about who you would want to act for you. And it might not just be your spouse. So it's so crucial that you have the documents in place laying out who you want to make those decisions. And then other important reason why you really need a power of attorney is because if you don't have these documents in place, letting your spouse or your children or your other loved one making these decisions for you, the alternative that they have to go through is a guardianship in order to be able to act on your behalf. The guardianship is incredibly time consuming and it's a very expensive process because you have to go through the court system. And essentially, whenever the court is appointing a guardian over you, the court is saying that you should not be able to make your own financial or medical decisions anymore. We're going to take away your right to do that, and we're going to have this other person make those decisions on your behalf. So it's a very intrusive process, and you lose a lot of power in the process of doing that. So I think it's extremely clear now why you really need a power of attorney and how much better of an option that is for you and for your family members. So now you probably have the question, okay, so I need this document and I need to appoint decision makers and agents, but who should I name as my agent in my power of attorney? Well, here at the firm, we actually recommend appointing more than one decision maker in your documents. Just in case one of them isn't able to act, we have a backup person ready to go. Okay, so who should you pick? Should you name your oldest child or the child who lives the closest to you? Do you have one child that's maybe a little bit more responsible than the others who would be better in this role? And should you pick the same person for all your documents, or should you name different people in different documents, depending on what the powers are going to be? And then if you are going to pick different people, more than one person, you should also think about how they're going to serve in relation to each other. Do you want child A to start making decisions? And then if child A isn't able to act, that's when child B starts acting then. Or do you want child A and child B to serve together at the same time? And if they are going to serve together at the same time, do they have to make every decision together? Or are either one of them allowed to act independently to do what they think is best for you? But ultimately, as you think through all of these questions and try to figure out who you should be naming as your power of attorney, the really crucial things that you should be thinking about is making sure that you name someone who you absolutely trust as your agent, because you are giving this person an incredible amount of power, and you want to make sure that you're naming the right person who you can trust to give this power to. You also want to make sure your agent you're naming is going to be very responsible and is not going to take this duty lightly, because with great power comes great responsibility, as we all know. And you also want to make sure that the person you're naming, maybe they have some certain skills that would make them better for one document over another. For example, maybe you have a child who's a nurse, and that person is would be a stronger fit for your healthcare powers of attorney and living wills or things like that. So those are different things that you really need to be thinking about in preparing for the second half of your life and thinking about your powers of attorney that you need to have in place. In addition to the powers of attorney, the other really essential estate planning document you have to have is a last will and testament. And the things that we're going to be looking at in your last will and testament is, of course, distributions of property. Who gets what? That is often what most people, what's on the forefront of their mind as they're thinking about their last will and testament. And here we actually also use a personal property memorandum as well. This personal property memorandum is a list that says that specific pieces of property are going to be going to specific people. And we found that this personal property memorandum can actually be a huge key in preventing a family feud from breaking out in your family. If you take the time ahead of time to think about, who gets mom's engagement ring and wedding band and who gets this family heirloom, it makes everything much smoother down the road if all those decisions are made ahead of time. Your last will and testament is also going to appoint your executor, or the person who's going to make sure everything gets to where it needs to go. and make sure your estate is administered fully and correctly. And you're also going to want to make sure that your last will and testament gives that executor the flexibility he or she needs to figure out the best way to distribute assets to your beneficiaries. So like I said, we're going to look at all of those things with your last will and testament. But again, the thing that most people are focused on with their will is the different distributions of property or the bequests that they're making to different people. And whenever you're doing your last will and testament, there are a couple of different kinds of bequests that you can include. And we're going to go through 4 different kinds of bequests that you can include on your last will and testament. So Kristin, if you could please explain this. There we go. Thank you. So there's 4 different kinds of bequests. You can have a specific bequest, which is saying, I want to give this specific piece of property to this specific person. Or you could include demonstrative bequests, which are saying that you want to give a certain amount of money to a specific person and you want to have it come from a specific source. So maybe you want to give $5,000 from your Kish Bank savings account to your daughter. On the other hand, maybe you want to include some general bequests saying, I want to give a certain amount of money to this person, but I don't really care where the money comes from. Executor, wherever you find the money, just take it and give it to my child. And the last kind of bequest is a residuary bequest. That's everything that's left. Who gets everything that's left over after all of the other bequests are taken care of? Those are the key things that you should be thinking about and what you need to include in your will. And the last essential estate planning document we're going to be talking about today is a trust. So why might you want a trust as part of your estate plan? Well, trust is really important because it allows you to protect some of your assets from your creditors and from the potential cost of your long-term care, which, as Kristin said, this can be a huge benefit because, as she said, long-term care is incredibly expensive. And so if we can try to protect as much as we can, that can be a huge benefit to you. Using a trust is really crucial because it allows you to choose what pieces of property you want to protect. You can choose what kind of property you want to put into the trust. The trust also lets you keep control of your property. You get to maintain a level of control that you wouldn't otherwise have if you were to just start gifting property away to your kids or to other people. And finally, the trust also lets you protect yourself and your spouse from any cost of long-term care you might incur in the future. So what exactly is a trust? A trust is its own separate entity that can hold and own property. And the trust document that you sign is really just a set of rules explaining what you can and can't do with the property that the trust owns. And in that trust document, some of the things that we're going to talk to you about and some of the things that we want you to be thinking about are who's going to be the beneficiaries, who has the right to enjoy the property in the trust, who do you want to name as the trustee, who has control over the property in the trust, do you want to name any trust protectors, and what are the powers of the trustee and the trust protectors? What do they get to do with regard to your trust property? We also want to think about how the property in the trust is going to be taxed and how that's going to look for you and for the beneficiaries. And we also definitely want to include a spendthrift clause in your trust. The spendthrift clause provides some layer of protection, which gives some layer of protection from your creditors and the creditors of your beneficiaries to prevent the creditors from reaching their hands in and having direct access to the trust. Now, sometimes whenever we recommend a trust for someone, they kind of are surprised because they have this misconception that a trust is just for rich people. And that is absolutely not true. There are many different reasons why you can have a trust, and you can set up a trust with any amount of money or a piece of real estate. There's no minimum amount that you need to put into a trust. Some of the main reasons why we might recommend a trust for you is, of course, probably the number one reason why we use a trust here is for asset protection planning, to protect your assets from your long-term care costs. But we might also recommend a trust for you if one of your beneficiaries has a disability and is receiving some kind of needs-based government benefits, or maybe you just want to distribute your inheritance to your beneficiaries in chunks over time. You don't want to give a lump sum to your beneficiaries. But if one of these reasons or another one of many possible reasons exists why a trust might be beneficial for you, and if we talk about that, the next step we're going to look into is whether you should have a revocable or an irrevocable trust. And a revocable trust, just like the name suggests, is fully revocable, and you have the power to change it whenever you want, in any way you want, basically. With a revocable trust, you also have direct access to the property that's in the trust. You can reach in and pull it out at any time. However, because you have access to the property in the trust, it's not protected from the cost of your long-term care. On the other end of the spectrum is an irrevocable trust. And you guessed it, an irrevocable trust cannot be freely revoked or freely amended whenever you want. But with an irrevocable trust, you don't have direct access to the funds that are in the trust, to the property put in the trust. But because your access is limited, the nursing home's access is also limited. Property you put in an irrevocable trust is protected, has more protection from your creditors and your long-term care costs. So those are the essential estate planning documents that you have to have: your powers of attorney, your last will and testament, and maybe a trust. And now that we've gone over those things, what you need to do now is meet with our office to review any existing estate planning documents you have in place. And possibly we might want to have you update your documents if either maybe you don't already have estate planning documents in place, or we want to help you put some good estate planning documents in place if your documents you have now could be made a little better. And through this process, we're here to help you avoid putting your family in a bad situation, like having them go through a guardianship or impoverishing them, or having them break out into an all-out family feud for some reason. We were able to do this exact thing with John and Denise Sassler, some previous clients of ours. And after we were able to help them get their estate planning documents in place, they said, "Thank you so very much for the exceptional services. The financial investment we made in your firm is suitable. For now, we have peace of mind in regards to our estate planning." So we're hopeful that we're able to work with you to give you the same peace of mind with your asset protection planning and making sure you have good estate planning documents in place. So at this time, I will pass over to Kristin to wrap up with our Family Feud poll answer number 3.
All right, thanks, Megan. Actually, just got off the phone with John and Denise right before we started the seminar. So, what we are going to talk about right now, I'm going to talk about why it's so important to protect your assets from long-term care. So do you know that if you do not put a plan in place and need some type of care, the state of Pennsylvania and the nursing home is going to tell you that you need to spend every last penny on your care, or that you might lose your home. We work with families every single day to make sure they do not lose their home, their life savings, all while protecting what's most important, their spouse and their families. Well, what is long-term care planning? Long-term care planning is the process of planning for your future while you are still able to make decisions and understand what options are available and the costs involved. By planning before you get sick, you control what happens. So a little bit earlier today, we talked about different types of care and options to pay for care. But if you need some type of care, what assets are available? What can the nursing home take or force you to use to pay for your care? Well, almost everything. This includes bank accounts, CDs, investments, life insurance, retirement accounts, real estate. Pretty much everything you own is available for your long-term care. And if you're married, your spouse's assets are also subject to pay for your care. So what can you do to protect your spouse? Well, we're really lucky here in Pennsylvania that we have fair spousal impoverishment rules and can protect almost everything for the spouse that doesn't need care. But as Megan mentioned earlier, you have to have good powers of attorney in place to be able to protect assets. Even if you're married, it actually doesn't matter. A good power of attorney is the only way that you can protect assets against your spouse's long-term care. What about your house? For most of us, our house is our most valuable asset. The good news is with proper planning, there are options available to protect your house, even if you need care right now and didn't plan ahead. Now, if you do not protect your house, the state of Pennsylvania will place a claim against your property after you pass away. So it's really important to be able to know what your options are to protect your house from an estate recovery claim. So how do you protect your assets? Well, every plan is different. I compare it to a puzzle, that we have to have every piece of that puzzle to make sure we're doing a good job. This really depends on your goals, your family situation, where you're receiving care, how much care you need, and your assets and your income. There's so many variables that we need to take into consideration when we put a plan in place. Now, there's many tools that we use to protect assets, but probably the two that most of you have heard of are irrevocable trust, as Megan just spoke about, and Medicaid compliant annuities. Well, I'm not going to spend a lot of time talking about either of these today. It is important to know that for almost every plan we put in place, we use either irrevocable trust or Medicaid compliant annuities, and in a lot of plans, a combination of both of these. So I just mentioned irrevocable trust, annuities. You might be thinking, well, wait a second, you're talking about gifts. Isn't there some sort of look back? How does gifting work with Medicaid qualification? So there's a 5-year look back when you apply for Medicaid. This is the 5-year period prior to your Medicaid application being filed. During this 5-year period, the state of Pennsylvania wants to ensure that you have not gave away any assets over $500 a month. It's not $15,000, it's not $12,000. Those are tax gifting rules. For Medicaid purpose, a gift is anything over $500 a month. Now, if you have made gifts, the state will total up the gifts and issue a period of ineligibility. So let me just clarify something. Just because you have made gifts doesn't always mean that you have to wait 5 years for Medicaid to pay for your care. But there is a process, and it must be done perfectly to start the penalty for the gifts that you've made within the 5 years, and now you need care. Let me give you an example. Let's say you gave away $100,000. That can be real estate, assets, anything you gave away. But now you need care within 5 years of making that gift. The state of Pennsylvania is going to issue an ineligibility period of 9 months. How we determine the ineligibility period is by taking the value of the gift, $100,000, dividing it by the average cost of care in Pennsylvania, which right now is a little over $11,000 a month, and we get 9 months. So that means you do not have to wait 5 years from the gift. You only have to wait 9 months until you qualify for Medicaid. So if you have enough other assets to pay for your care for those 9 months, no problem. You protect the gift, you just pay 9 months for your care. But what if you do not have enough money to pay through that 9-month penalty period? Well, then there's a lot at risk, such as not qualifying for Medicaid, not being admitted into a facility, or even filial responsibility, which means that your children can be held legally responsible for your nursing home bills. I do not know many people who would want to put their children in that type of position. Now, lastly, we must mention when we're talking about gifting that we do not recommend outright gifting. We recommend using irrevocable trust. The reason we do not recommend outright gifting to your children, even if they are the most wonderful children in the world, is because what we refer to as the 4 Ds: divorce, debt, disability, or death. Let me give you an example. You give $100,000 to your son and he gets divorced. Well, that gift could now be part of the divorce settlement. You give $100,000 to your son and he becomes disabled. Well, he may not be able to receive the benefits that he needs. You give $100,000 to your son and he has creditors or he has some sort of debt. Now that's available for his creditors. Or what if, God forbid, you gave $100,000 or a house to your son and he passes away before you? What does his will say? Does he have a will? Now we have quite the mess on our hands. So when we're talking about gifting, it's really important that you're working with an elder law firm to make sure you're doing it in a really structured manner, that you're not going to negatively impact any benefits or care that you need in the future. Because unfortunately, we don't have a crystal ball. Even the best laid out plans for your future could really crumble if something unexpected happens. Now, we've talked a lot about benefits, options for care, and knowing what to do. And I know it's really confusing, but what can you do? Put a plan in place. By putting a plan in place, you control what happens if you need care, who makes decisions for you, and ultimately the outcome. Now, I know the last section that we talked about was a little overwhelming and even a little scary, but think about this. Do you want somebody else to make decisions for you? Do you want to burden your family by not having the conversation or not having a plan in place? Of course not. Let's go back to Nancy. Nancy didn't have a plan. She was told that there was nothing that could be done. She was hopeless and felt like nobody was on her side. Now, thankfully, her friend told her to call us, and we were able to jump into action and help her. But what if her friend didn't tell her to call us? She could have lost everything: her house, her income, her assets, and probably her will to keep moving forward each day. Do you have a friend like Nancy? Maybe, but maybe not. Do you want to leave it up to chance? Of course not. So, what do you have to lose? Think about that for a moment. What do you have to lose? While we think about what you have to lose by not putting a plan in place, let's recap what we've talked about today. We've talked about what options you have for care and how to pay for that care. What happens if you do not have good estate planning documents? The options that you have for leaving a lasting legacy for your children. And what happens if you do not put a plan in place to protect your assets? After everything we've talked about today, I hope you get this one thing. Planning ahead is essential to make sure your family is taken care of and you do not spend any more than necessary on long-term care. How do you avoid a family feud? So what can you do right now to avoid that family feud? You can schedule a long-term care strategy session. What is a long-term care strategy session? How does it work? This is a 1-hour strategy session with our office via Zoom or a telephone call.
So as Kristin was saying, how this 1-hour strategy session is going to work with our office is it's either going to be a 1-hour session via Zoom or phone call. And during this meeting, we're going to make sure that your estate planning documents are in good order, that you have all the documents you need in place to make sure you and your family are taken care of. We're also going to develop a plan for the second half of your life, and we're going to answer all of the questions that you have about your unique and individual situation. Because even though we made a lot of generalizations about the documents that you have to have in place, everyone's situation is unique, and we're here to help you individually figure out what is best for you and for your family. And at the end of our time together at that strategy session, you're going to know exactly what documents you need to have in place. You're going to know the different options you have and the best options for you for paying for your long-term care. And ultimately, you're going to have the peace of mind knowing that you and your loved ones are going to be ready for the challenges of tomorrow. So after our meeting, this is what we're going to do on our end after we meet with you. We're going to develop a written plan of our recommendations of what you should do moving forward for yourself. And this is going to be a pretty simple and clear roadmap of what is going to happen next that you can follow. It's going to be available for your family to reference to when the time comes for them to start acting for you. Then we're going to help you implement this plan. We're going to help you put this plan in place by giving you any legal documents that we prepare and making sure that those are in good order, and making sure that your asset protection and trust funding is finished properly, if that's the best option for you. And most importantly, after we meet, we're going to help you walk through this step by step to make sure everything is in place. We are going to be with you through this whole process from start to finish to guide you and assist you through this. So typically, the value of this 1 hour strategy session with us is around $495. But because we really appreciate you taking the time to sit down with us today at this seminar, we're going to offer this we're going to offer this 1 hour strategy session to you absolutely free as a thank you for joining this seminar. And so what's the catch? So really, there is not a catch. The only thing that you need to do is there are limited spaces available for appointments. Our schedules tend to fill up pretty quickly, but we have set aside some appointments for those of you attending this seminar today who would like to sit down with us. So if you would like to book your strategy session and get in while these appointments are still available, please click on this link, chatwithsgy.com, which Haley's going to put in the chat box for you for easy access, or you can call us at our toll-free number. So remember, we've covered a lot of information over the past hour, but really, after you sit down and meet with us, you are going to know the options for your long-term care, including how to protect your hard-earned assets from the rising long-term care costs. You're going to know what legal documents make the most sense for your family, and you're going to have an estate plan in place that's going to provide for the future generations of your family. And ultimately, you will have the peace of mind knowing that you and your loved ones are better prepared for any challenges that might come your way tomorrow. So once again, in order to book your strategy session to get started on this process and to get that peace of mind, the link is going to be chatwithsgy.com, or you can call our toll-free number. Thank you so much for jumping on this seminar with us today. We really appreciate you taking time out of your Wednesday morning to talk with us.